convicted felon Donald Trump is looking more desperate than ever in the New York criminal appeals. We all know that Trump was convicted on 34 felony counts. He tried to file a motion for a new trial. I think he actually cited on page 15 and 16, was it? MeidasTouch several times. He was like blaming us in our shows also. As you remember that, Harry, as part of
I'm
the
very
grounds.
jealous. He did, yeah.
As part of the grounds why he wanted it overturned. But if that wasn't desperate enough, now he's arguing to the Second Circuit Court of Appeals that this case should never have been in the state court system, that it should have always been a federal case. And so he's asking the Second Circuit Court of Appeals, which oversees the New York federal courts, to intervene. I mean, Harry, what I think I'll give you his argument. His argument is that his defense of absolute immunity, based on what the Supreme Court's ruling was, as it relates to evidentiary objections, if during the trial they talked about certain things that occurred during the first Trump administration, even though the criminal conduct predates the first Trump administration with the hush money payments, there was some evidence which ultimately the trial court judge, Justice Meran, said that was harmless error, had nothing to do with the impact of the case. But it did involve, at least, there was a meeting in the Oval Office, and Cohen was there. And then here's how Trump got his mail when he was in the White House. So there was some references, to him being in office. So he's saying because of that, the whole case should have gone into federal court. Harry, what I think he's really positioning here for is the fastest way to go to the United States Supreme Court, to go to his friends in the Supreme Court and ask for a get out of, he never went to jail for it, despite my belief he should have, but a get out of which he should have gone to jail free card, and remove what he sees as this blemish.
Remove the scarlet letter, right? Which he's obsessive about, even though he got it real easy. So, Ben, this is a recycled claim on his part. He's tried it in many different ways. He has always failed, including trying to remove early on, but waiving it. We've had different judges say, no way. To understand the claim, it's not, because as you say, this is candidate Trump, no possible argument of immunity. But what he's saying is there were a couple things introduced to the jury, especially when more than a few months into his presidency, the Wall Street Journal gets the story, they're publishing it, and Hope Hicks, who's then his communications director, has a conversation. None of it matters for a couple reasons. First, the courts ruled that even that wasn't official. When you're, just because you're in the Oval Office doesn't make everything official. But most importantly, as you said in passing, but as Meran held flat out, it's harmless error. And by the way, I attended the trial, and I am here to tell you, it was harmless error. None of that encounter with Hicks, which was really just used to show, they were worried about Stormy Daniels. They were worried before. They were worried after, in any way was pivotal to the conviction. He gets convicted either way. So what he's trying to do is take what is really a state harmless error analysis and somehow gussy it up as a federal claim, but it's a claim that's already been lost. One little asterisk: when you mention his buddies in the U.S. Supreme Court, one of them, Justice Barrett, did go for him on immunity, but it was this aspect of the Roberts Court, the other five, that she parted company with. She said, just because he's immune in conduct doesn't mean you can never consider the evidence. So I suspect she wouldn't be there to vote for him in any event, even if it wasn't harmless error. But basically, he's asking the Second Circuit to buy a headache of a claim that was already waived, and here just isn't presented. Because what is presented is a state court analysis that says, doesn't matter what the claim was, it was harmless error. You can analogize it, say, to a confession. and somebody makes an improper confession, shouldn't be in there. But if we have the videotape and the fingerprints and the DNA, they're going to be convicted anyway. And even if they want to say the confession wasn't kosher under the Constitution, it doesn't matter. And it doesn't matter for state law reasons. So you're right. This is him, just a Hail Mary on a Hail Mary on a Hail Mary. I don't expect it will get anywhere. At some point, he may try to serve up this claim, but just because they gave him immunity, and even because not only, but even that they said you can't bring evidence in, that doesn't mean his conviction gets reversed. That's what harmless error means, and you have it every day. And one more point, it's the kind of silliest, smallest issue that in normal times the Supreme Court of the United States would never take. It's not a federal question of was that harmless or wasn't it harmless error. So if you see them even interested in it, it'll mean that there's a cadre of the court that is just looking to do him one more solid. But the case has really nothing to do with removal, nothing to do. It's a state law harmless error analysis. And the Second Circuit, I think, will see through this gambit.
Well, Harry, I've always said that it turns out when the right-wing Supreme Court said they were conservative, it was about conserving the monarchy, not conserving our democracy. That's what they really meant by their originalist interpretation. They wanted to go back to the earliest days when the Magna Carta was first written. But Harry, a few observations. Number one, Justice Meran, the trial court judge in the state court system, really gave a bulletproof order as much as you can from the intervention, as I said, of these monarchist conservatives. You can't stop them if they're going to, do what they're going to do. But he made it clear on multiple levels under any analysis, here's why Trump loses this case. And so I think he did everything that he can do in terms of, as well as, which I think people got upset about, the fact that while Donald Trump is not serving any prison time, the fact that Trump was declared a felon, you can see how much that is just bothering Donald Trump there, which brings me to my next point, which is, here's the thing with the Supreme Court. If you give Donald Trump an inch, I've always said this about him in general, he takes your life. Like he literally, like they handed him the biggest gift with absolute immunity, and the contortions that they went through during the oral argument to protect him was so utterly pathetic that it isn't even bearing repeating, other than it was humiliating as a lawyer to even hear what these right-wing justices would say. But then you give him that. He doesn't do jail time. They think they're doing him a favor. And what does he do? He goes right back to them and said, actually, what your order was a declaration of monarchy, right? We want you to go there. To which, now they're going to be put in a situation where, with all of the other things that Donald Trump is doing to screw over people, Donald Trump's relationship with Putin, his attacks on Ukraine, his supporting of the billionaires and the oligarchs, his tariff trade wars that are crushing our allies and crushing America. Now he goes to the democracy piece and goes, I want you, Supreme Court, to hear this. And if you don't hear it, I'm going to post about you, and I'm going to say that the Supreme Court is crap. And then all of my people that you thought you were avoiding by handing me this gift, they're back going after you again. That's and that's why you can't deal with this guy like that. I'll give you the final word.
Well, you're right. Look, he's a bottomless grievance machine, and it's all, what have you done for me lately? But as always, we just have to hope that the law holds, and that at least this one won't be the venue for them to really stretch and take a state law itty bitty issue and federalize it the way Trump would like.
Absolutely. Well, we'll keep you posted every step of the way. Harry Litman's Talking Feds. It's on Substack. It's on YouTube. It's on podcast. You just search Talking Feds. Why? Because Harry's a former Fed. He talks. He clerked in the Supreme Court twice. And who does that? Led the Western. Harry, led the Western Division of Pennsylvania as the United States Attorney, was a top person at the DOJ fourth floor. So that's why I get my legal news, because Harry is smarter than me on these issues, but that's how I get educated to teach all of you. So if you want the OG source, it's Harry Littman, talking feds across the board. Thanks, Harry.
Thanks, Ben. Talk to you.
Subscribe. Let's get to 5 million.
Can't get enough Meidas? Check out the Meidas Plus Substack for ad-free articles, reports, podcasts, daily recaps from Ron Filipkowski, and more. Sign up for free now at MeidasPlus.com.